So friends, taking on the tone and tenor of their client, Donald Trump's lawyers file an over-the-top motion demanding that Judge Tanya Chutkan hold special counsel Jack Smith in contempt. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump's lawyers just filed a motion insisting that Judge Tanya Chutkan, who is presiding over Donald Trump's D.C. trial for election interference, for trying to overturn the results of the 2020 presidential election, they are demanding that Judge Chutkan hold special counsel Jack Smith and his team of prosecutors in contempt. Why? For giving Trump's lawyers additional evidence, additional discovery, for filing a motion, and for giving them an exhibit list. Let's start with the new reporting. This from NBC News. Headline: Trump team seeks to grind D.C. election interference trial to a complete stop. Trump's lawyers want the special counsel to be held in contempt for providing them with discovery material and filing motions ahead of deadlines. And that article begins, attorneys for former President Donald Trump are once again pushing to delay his federal election interference trial, telling a judge that special counsel Jack Smith and federal prosecutors should be held in contempt for filing motions ahead of deadlines and continuing to provide Trump's team with discovery, that is, with evidence. John Lauro, a Trump attorney who has argued that Trump's election interference trial should be delayed until 2026, that is, long after the next presidential election, filed a motion Thursday calling for the special counsel to be held in contempt for what Lauro called an unlawful production of discovery, accusing federal prosecutors of partisan-driven misconduct. Lauro argues that Smith cannot keep filing because U.S. District Judge Tanya Chutkan paused the proceedings in the case in December while an appeals court considers Trump's contention that he can't be prosecuted because of presidential immunity, though the March 4 trial date is still on the books. But in that order, Chutkan made clear that the deadlines were merely held in abeyance rather than permanently vacated, and noted that the purpose of the stay was for the benefit of Trump's team so as to not impose additional burdens of litigation on Trump as he pursued the appeal. There was nothing in the order that barred federal prosecutors from continuing to proactively provide discovery or file motions even though the deadlines were lifted. Chutkan explicitly raised the possibility that she would retain deadlines if the appeals court rejects Trump's presidential immunity claim. If jurisdiction is returned to this court, it will, consistent with its duties to ensure both a speedy trial and fairness for all parties, consider at that time whether to retain or continue the dates of any still future deadlines and proceedings, including the trial scheduled for March 4, 2024, Judge Chutkan wrote. Okay, friends, now let's turn to the inflammatory, hyperbolic nonsense filed by Donald Trump. In the case of United States of America versus Donald Trump, defendant, the motion is captioned, President Donald Trump's opposed motion for order to show cause why prosecutors should not be held in contempt. And the motion opens, President Donald Trump respectfully moves this court for an order to show cause why prosecutors Jack Smith, Molly Gaston, and Thomas Windham, collectively the prosecutors, should not be held in contempt for violating the court's order staying any further proceedings that would move this case towards trial or impose additional burdens of litigation on defendant. Now remember, friends, what we're talking about here is Jack Smith and his prosecutors giving additional discovery, additional evidence to Donald Trump's defense team, so they will have it, and when the case again is put on the trial track, they will have had it for some time, to be better prepared to defend their client. Jack Smith's team gave them some additional discovery. Jack Smith's team filed a motion that doesn't have to be responded to by the defense at this time, and they gave the defense team what's called an exhibit list, which is simply showing the defense team the numbers that they're assigning to each piece of evidence that they may intend to introduce at trial. So the defense motion continues to remedy this outrageous conduct of giving the defense those things. The court should issue an order to show cause why the prosecutors should not be 1. Held in contempt, 2. Required to immediately withdraw their MIL, their motion in limine, and improper productions, 3. Forbidden from submitting any further filings or production absent the court's express permission while the stay order is in effect, and 4. Assessed monetary sanctions in the amount of President Trump's reasonable attorney's fees and expenses incurred in responding to the prosecutor's improper productions and filings, including in litigating this motion. But wait, there's more, because the defense contends that all of this is really just exposing the prosecutor's unlawful goal, unstated but obvious, is the prosecutor's desperate effort to harass President Trump and prevent his likely victory in the 2024 presidential election. It has nothing to do with efficiently moving this criminal case, this prosecution of Donald Trump for his democracy-busting crimes through the system. No, the whole thing is just a ruse because the prosecutors just want to stop Donald Trump from winning in the next election. And then, friends, if you'll permit me one more passage, which is a little bit of insider baseball, but I want to touch on it to highlight just how absurd some of these claims are. They contend that the prosecutors are attempting to unconstitutionally try President Trump in absentia by continuing to submit filings and other pleadings pertaining to the government's trial presentation. So, friends, the reason I wanted to quote that passage, it may sound like a bunch of legal mumbo-jumbo, but let me unravel that for you as a prosecutor who tried someone in absentia. The defense claims that this demonstrates Jack Smith is trying President Trump in absentia. What does that involve? The only way you can try someone in absentia is if after the jury is sworn, after jury selection, when it gets down to 12 jurors and a number of alternates, and the judge says to them, please raise your right hand so I can administer the juror's oath to you. And the judge swears in the jury. After that moment, which represents, legally speaking, the commencement of the trial, if a defendant voluntarily absents himself or herself from the proceedings, from the trial thereafter, the law provides that person can be tried in absentia, in their absence, through the conclusion of the trial, and the jury can convict them in their absence. Let's be real clear. That is what trial in absentia means, and that's what it involves. And so for lawyers to put this kind of garbage in a pleading in federal court or in any court that the prosecutors are trying Donald Trump in absentia? You know, that is so ridiculous, it just falls under the weight of its own frivolity. The legal term I would use for something like that in a legal filing is just plain stupid. So friends, thank you for indulging me that bit of inside legal baseball as a prosecutor who has actually tried a defendant in absentia. Frankly, if you're interested in hearing more about that case, it's the case of United States versus Albrecht Muth, M-U-T-H, and it was made into a major motion picture called Georgetown, directed by and starring Christoph Waltz. But I digress. So friends, let's finish with this. You know, if we weren't living in a post-irony world, I would probably spend some time talking about how when these kinds of motions get filed, it's generally because prosecutors aren't turning over enough discovery or enough evidence, or they're not turning it over quickly enough. Why? Because the defense attorneys typically want as much time as possible with the evidence so they can better prepare their client for trial when the trial date ultimately rolls around. But the defense is complaining about something entirely different here. Don't give us evidence too much too soon. We don't want it. We don't want to spend any time preparing for trial, even though a trial date is coming. Friends, rest assured, a trial date is coming. But at this point, suffice it to say, this motion will be denied. Judge Chutkan will not hold Jack Smith and the other prosecutors who are hard at work trying to hold Donald Trump accountable for his democracy-busting crimes. Judge Chutkan will not hold them in contempt. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.